Welcome to the deep dive. We've got quite a stack of sources today, spanning, gosh, centuries, really. We're jumping from the very messy birth of Athenian democracy all the way to the, well, the highly organized, sometimes brutal, legal world of the Roman Empire.
That's right. And our goal isn't just to look at history, it's to dig into the operating system, if you like. How did these two massive ancient powers actually structure their power? How did they do justice, or what they call justice? We're looking at the mechanisms, the rules for war, for social status.
It's fascinating because they took such different paths. Athens, with its focus on rhetoric, on the people being directly involved.
And Rome, with its incredible legal engineering, adapting old laws, building this complex structure. We want to see how law actually works in these places, how it changes, how it adapts, and crucially, how it enforces who's on top.
Okay, let's dive straight in then. Part 1, Athens. And the story starts, maybe surprisingly, not with philosophy, but with a fight.
Yeah, we often get this picture of Cleisthenes, the wise founder, calmly setting up democracy. But the sources, they really stress something else, don't they? That this whole reform, it basically happened under the threat of violence.
Oh, absolutely. It had to. Think about what Cleisthenes was doing. He was shaking up the whole power structure, moving it away from the old aristocratic families towards, well, the demos, the people. That wasn't going to happen without a pushback.
And the pushback came fast. His rival, Isagoras, he didn't just debate him.
Nope. He went straight for outside help. He called in the Spartans. King Cleomenes.
The Spartans, who famously disliked democracy, right? They saw it as just chaos.
Exactly. So Cleomenes marches in, backs Isagoras. Their plan, scrapped the whole new constitution.
Yeah.
They started by trying to expel hundreds of families, including Cleisthenes' own clan, the Alcmenids.
Yeah.
Used some old religious pretext claiming they were cursed.
Talk about playing dirty. So they try to shut down the democratic experiment right at the start. They occupy the Acropolis, the symbolic high ground of Athens. Cleomenes, Isagoras, a Spartan force. It looks like it's over before it began.
But then the people step in.
This is the crucial part. The ordinary Athenian citizens, the ones Cleisthenes had just empowered, they didn't wait for orders. They rose up. They surrounded the Acropolis and besieged the Spartans.
A citizen militia besieging a Spartan king.
It's incredible, and it worked. After just 3 days, Cleomenes was forced to give up, to surrender, and leave Athens with his tail between his legs.
Wow. That's a powerful image. A Spartan king backing down to Athenian citizens. It really underlines that Athenian democracy wasn't just an idea. It was backed by this willingness, this necessity to use force to defend itself right from day one.
It sets the stage, doesn't it? This constant tension between potential chaos, street violence, factional fighting, and the attempt to create order through law. They won through force, but then immediately set about building systems to manage conflict without always resorting to force.
Which brings us neatly to their justice system. How do you channel all that energy and conflict into something, well, manageable?
Well, the first idea was pure democracy in action, the Haleia. Originally, that wasn't a specific court building or anything. It was just the assembly of the people acting as the main judicial body.
So literally everyone turns up to judge cases.
In theory, yes, but you can see the problem, right? Thousands of citizens, hundreds, maybe thousands of cases. It just wouldn't work practically for a busy city.
Yeah, you'd never get anything else done, so they had to adapt.
Exactly. They got systematic, they kept the name Haleia, but they subdivided the people's judicial function. They created these large jury sections called decuries.
And these were huge, weren't they?
Massive. Every year, they selected 6,000 citizens by lot. These had to be men over 30 years old. They drew 600 from each of the 10 tribes that Cleisthenes had set up.
6,000 people. Just think about the logistics of that. Managing the lists, the assignments.
It's quite something. And these 6,000 were then organized into 10 panels, 10 decuries of 500 jurors each, plus 1,000 held in reserve. So you had these large standing juries ready to hear cases.
This is the system we read about in the big speeches, Demosthenes, Lysias.
Yeah.
They're talking to these huge crowds of jurors.
That's right. But what's really ingenious, and maybe speaks to the ongoing fears of corruption or influence that came out of that initial conflict, is how they tried to ensure impartiality. They set up this incredibly complex lottery system.
Ah, so it wasn't just selecting the 6,000, the lottery continued.
Oh, yes. The officials in charge, the archons called the thesmothetes, they had a crucial job. Right before a trial was due to start, they would use another lottery to decide which of the 10 panels of 500 jurors would sit that day, which magistrate they'd sit under, and which cases they would hear.
So if you were bringing a case or defending yourself,
Yeah.
You literally wouldn't know who your judges were until the very last moment.
Exactly. The idea was to make bribery or intimidation impossible. You couldn't target specific jurors beforehand. You couldn't easily tailor your arguments to a known group. It's a really early, fascinating attempt at ensuring jury anonymity and fairness.
That's quite sophisticated. But serving on juries takes time. How do they make sure people actually did it, especially poorer citizens?
That's the catch. The sources tell us this constant demanding jury service only really became sustainable for everyone after Pericles introduced pay for jurors.
Ah, so pay was key.
Absolutely. Before that, it was mostly the wealthier citizens, those who could afford to take time off, who could realistically serve. Pay democratized justice, made sure the system could actually function with broad participation. It wasn't just a fee, it was fundamental to making the system work as intended.
So a system born in conflict, managed by complex lotteries, and ultimately funded to ensure popular involvement. That's quite a picture. Hashtag tag 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 see warfare status and propaganda in Greek conflict.
Now, let's shift arenas slightly. From the law courts to the battlefield, where status and reputation were just as fiercely fought over, maybe even more so. And the prime example has to be Thermopylae.
The ultimate story of heroic sacrifice, right?
Yeah.
Especially for the Spartans.
It cemented their reputation for centuries, and the sources love these little details that capture it, like the famous line from Dionysius.
Remind us of that one.
When someone said the Persian arrows would be so thick they'd block out the sun, he supposedly just quipped, "Excellent, then we shall fight in the shade."
Classic Spartan understatement. That kind of story becomes political currency, doesn't it?
Absolutely. But history isn't always clean. The sources also push us to look at how these events were immediately spun, how military outcomes affected political status, sometimes unfairly.
You mean beyond just celebrating the heroes?
Yes. Look at the contrast drawn between the Thespians, who stayed and died with Leonidas and are remembered as heroes.
And the Thebans, who were also there but surrendered.
Exactly. There's this nasty story that circulated claiming the Thebans were treacherous all along, suspected of Midizabin being pro-Persian, and that Leonidas only kept them there as hostages. And when they surrendered, they were supposedly branded like runaway slaves.
Branded? That's incredibly degrading.
Utterly. But the source we have argues this whole contrast, this specific story of branding the Thebans, was likely invented later. It was propaganda created after Thebes had indeed sided with Persia in later conflicts.
So they retroactively smeared them at Thermopylae to justify later hostility.
Seems likely. It shows how military events and perceived loyalty were weaponized. Failing on the battlefield or being seen as disloyal could lead to this kind of historical character assassination, effectively a form of legal and social punishment written into the narrative. Your city's status could be ruined by a story.
Fascinating and grim. Now, shifting focus to the Persians for a moment. We tend to focus on Xerxes' big invasion of Greece, but Darius's earlier campaign, way up north beyond the Danube into Scythia, that tells us something different, doesn't it, about the economics of war?
Yes, it's often seen as just this big show of force terrifying the Scythians. But the sources hint at more practical goals. It wasn't just about terror. It might have been about gold.
Gold? Where from?
From Dacia, the land of a people called the Agathyrsi. The theory is Darius wanted to secure access to their gold mines, and also, crucially, secured the supply lines and communication routes back to the Danube.
And there's evidence for this. It wasn't just a quick raid.
Well, the sources mention the Persians building forts on the river Owaros, which is thought to be a tributary of the Danube system. Building forts suggests a longer-term strategic presence, not just a punitive expedition. They were trying to control territory, likely for resources, even while facing resistance from the locals, like the Agathyrsi.
So even these seemingly distant, almost mythological campaigns, they likely had hard economic drivers. Force projection to secure resources and status.
It's a constant theme. Military action, political status, economic game, they're all deeply intertwined. ###D. The weaponization of rhetoric in Athenian courts.
Okay, let's bring it back to Athens, back to those giant juries in the courts. Because if conflict and status were playing out on battlefields, they were definitely playing out in the courtroom using words as weapons.
Oh, absolutely. The courts became the main stage for political rivalries. The feud between Demosthenes and Aeschines is the classic example. It went on for years, it was deeply personal, and the courtroom was their battleground.
And Demosthenes actually accused Aeschines of misusing the system, didn't he?
He did. He basically said, look, you're not here bringing legitimate charges about harm done to the city Kakagoria. You're just here for loidoria, personal abuse, insults, settling old scores. He's drawing a line, saying the court is for public justice, not private vendettas.
But that line must have been incredibly blurry in practice, which meant your skill as a speaker, your rhetorical strategy, was everything.
Paramount. And some were masters at it. Look at Lysias in his speech against Agoratus. His strategy for manipulating the jury is quite something.
What did he do?
He constantly explicitly addresses the jury as to "you meftron Foucault," which means something like "your multitude," but carries the strong implication of "your democracy, you Democrats."
So he's constantly reminding them of their shared political identity.
Exactly. He's constructing the jury in his speech as this unified bloc of Democrats whose interests are directly threatened by the defendant, Agoratus, who had acted as an informer during a previous oligarchic period.
So convicting Agoratus becomes an act of defending their democracy, their own safety.
Precisely. He aligns the jury's self-interest completely with this prosecution. It's not just about the facts of the case, it's about us versus them. A brilliant, if maybe cynical, rhetorical move.
Talk about knowing your audience. But Lysias faced a legal hurdle too, didn't he, with the amnesty?
Yes, the amnesty of 403 BC. After Athens overthrew the oligarchs, they passed an amnesty forgiving most political crimes committed during that period. It was meant to heal the city.
But Agoratus had been an informer, leading to people being executed. Lysias wanted him punished.
Right. The amnesty had a loophole, though. It didn't cover auto-chair and own-hand killer, someone caught red-handed, literally in the act of killing.
But Agoratus hadn't physically killed anyone with his own hands. He informed on them. How could Lysias get around that?
By redefining the crime through rhetoric. He argued to the jury that killing someone by delation, by informing on them knowing it would lead to their death, was legally the same as killing them with a club or a knife. He tried to make Agoratus legally equivalent to an auto chair.
He's trying to argue the informer's word is the weapon.
Exactly. He's weaponizing the definition of murder itself to bypass the amnesty and nail his political enemy. It shows the incredible flexibility or perhaps slipperiness of the Athenian system. Justice wasn't just in the laws, it was in the arguments, the performance, the ability to persuade those 500 jurors.
It sounds exhausting. Very public, very reliant on swaying this huge group of citizens. Now let's shift gears completely. Let's go to Rome. They faced similar problems, expansion, complexity, conflict, but they found very different solutions, didn't they? More structured.
Definitely more structured, less reliant on mass public persuasion, more on legal machinery, and crucially on specific magistrates.
Roman law, you often hear about the Irilis Civil, the old civil law, based on things like the 12 tables. Sounds very rigid, very fixed.
And it was, in theory. That rigidity gave it authority, a sense of ancient tradition. But you're right, a purely static law code can't cope with the world that's changing, expanding, becoming more complex with trade, foreigners, new kinds of disputes.
So how did Rome avoid its legal system justing or becoming irrelevant?
The key innovation, the engine of adaptation, was the Praetor.
Okay, the Praetor.
Yeah.
A high-ranking magistrate elected each year. What was so special about the Praetor's role in law?
The Praetor wasn't technically a lawmaker. He couldn't just write new laws or abolish old ones from the Ilias Civil, but he controlled procedure. And crucially, each year, when a new Praetor took office, he issued his edict.
The Praetor's edict. We hear a lot about that. What was it?
It was a public proclamation, essentially the Praetor's legal program for his year in office. He'd announce which legal actions, which formulas, which defenses he would recognize and enforce. He couldn't change the law, but he could grant new remedies.
Ah, so it's about access to justice. He could decide how the law was applied.
Exactly. And by doing this, year after year, Praetor after Praetor, building on the work of their predecessors, they created a whole body of practical, adaptive law alongside the old Ulvis Civil. This is what's called the Ulvis honorarium, or Praetorian law.
So the edict was the mechanism for keeping Roman law relevant and flexible.
Precisely. It allowed Roman jurists, as one source puts it, to grapple most sincerely and most extensively with the complexity and diversity of the world ancient political action had brought into being. As Rome grew, as new peoples came under its rule, as trade created new situations, the Praetor's edict could respond far more quickly than formal legislation.
Okay, let's look at the specific tools the Praetor used within that edict. What kind of new remedies could he create? There's the actio in factum.
Yes, the action on the facts. This was a really important one. It was an action the Praetor could grant when someone had suffered a wrong, but there was just no existing action available under the old, rigid Sixtius Civil to cover it.
So if the facts showed someone deserved a remedy, But the old law books didn't mention that specific situation.
The praetor could say, okay, based on these specific facts, I will grant an action. He wasn't creating a new general law, but he was providing justice in a novel situation. It showed a willingness to look beyond the old forms when fairness demanded it.
That's incredibly pragmatic. What about the actio utilis? That sounds useful.
It was the useful action. This was maybe even more subtle. It didn't create a totally new action like the actio infactum. Instead, it extended an existing civil law action to cover a situation it didn't originally apply to. And it did this using a legal fiction.
A legal fiction? You mean pretending something was true when it wasn't?
Sort of, yes, for legal purposes only. A classic example involved peregrines foreigners living under Roman rule. Let's say a peregrine suffered a type of injury for which only a Roman citizen could sue under the inceus civil. The praetor couldn't just make the peregrine a citizen,
Right.
but he could grant an actio utilis, which essentially said, for the purpose of this lawsuit, we will treat this peregrine as if he were a citizen so that he can use the citizen's legal action.
Wow. So the original law remains unchanged on paper, but the praetor cleverly bends the procedure to make it work fairly in a new context.
Exactly. It maintains the integrity of the old law while achieving a just result. It's legal ingenuity at its finest, allowing the system to adapt to a multi-ethnic empire without constantly rewriting the foundational laws. It shows this Roman focus on procedure as the way to get things done.
And these praetors and other magistrates, they wielded real power with these tools, didn't they? There's an example with Verres, the corrupt governor of Sicily.
Oh, yes. Cicero tells the story. Verres was notoriously corrupt. His successor, Metellus, came in and was appalled by what Verres had done through his official edicts and judgments in Sicily.
So Metellus reversed his decisions.
He went much further. Cicero says Metellus ordered Verres's official proceedings, his judgments, his orders to be sustulit atque irrita usit esse. That means he removed them and ordered them to be null and void.
Not just overturned, but declared legally non-existent, like they never happened.
Precisely, a complete erasure. Cicero notes Metellus was ready to nullify Verres's entire 3 years of rulings within a month, though other officials apparently slowed him down. But it shows the incredible power vested in these magistrates to correct perceived injustices, to literally rewrite the legal reality created by a predecessor. That's serious procedural muscle.
So Rome developed this really flexible, adaptable system on the procedural side, largely thanks to the Praetor's Edict. But when we turn to criminal law, especially punishment under the empire, we see something else entirely, something incredibly rigid.
Yes, a stark, brutal hierarchy based purely on social status. This gets formalized in what's often called the dual penalty system, explicitly laid out in imperial rulings, like edicts from Emperor Hadrian.
Dual penalty, meaning different punishments for the same crime depending on who you were.
Exactly. The law made a fundamental distinction between the honestiores, the more honorable people, the elite, senators, equestrians, local bigwigs, and the humiliores, the more lowly people, the common masses.
Okay, so what happened if you were an honestior and committed a serious crime, even a capital one?
Actual execution was rare. The punishments focused on destroying your status, your wealth, your place in society. Things like deportatio, permanent exile, usually to some remote island, involving loss of citizenship and confiscation of property, or relegatio, a milder exile without loss of citizenship. Or if you were in the Senate or a town council, modi or ordine expulsion. Your life was usually spared, but your social existence was ruined.
Right. Degradation, but not necessarily physical destruction. Now contrast that with the humiliores.
For the lower classes, the punishments were horrific. The summum supplicium, the highest penalty, often meant aggravated forms of death designed to inflict maximum pain and public humiliation.
Like what?
Crucifixion, crux, being burned alive, vivis iuri, being thrown to wild beasts in the arena, bestia stari. These were standard sentences for humiliores for crimes that might get an honestior merely exiled.
That's chilling. And if they weren't executed?
Then they faced punishments designed for grueling, often life-destroying labor. Ad metallum, sentenced to the mines, basically a death sentence through exhaustion and brutal conditions. Or in opus publicum, forced labor on public works projects. The aim was physical suffering and exploitation.
So the law itself enshrined this idea. Elite bodies are protected, common bodies are disposable or breakable.
Absolutely. And this distinction started even before conviction. Think about pretrial detention.
How did that work?
Well, honestiores were generally spared imprisonment before trial. Legally, jail wasn't seen as a punishment, poena itself, just a way to make sure you turned up for court. Corsidio. So high-status individuals were often under guard in their own homes or had private arrangements.
But for the humiliors.
They could be, and often were, imprisoned. And worse, torture, which in the early Republic was mostly reserved for slaves to extract evidence.
Yes.
By the 2nd and 3rd centuries AD, its use was extended. It could legally be applied to low-status freeborn citizens, humiliors as well, both during investigation and sometimes even as part of the punishment.
So the legal system explicitly said your body could be subjected to state violence simply because of your lower social rank.
It's perhaps the clearest, most brutal example of law being used not just to regulate behavior, but to actively maintain and enforce a rigid social hierarchy. The procedural flexibility we saw earlier existed alongside this incredibly harsh, status-based system of punishment. Check and G. The evolution of family law and citizenship.
And this theme of status and how law adapts or doesn't extends into private life too, right? Into family law. Like the guardianship of women.
Yes, the concept of tutela mulierum. Roman law traditionally required women, even adult women, to have a male guardian, a tutor, for certain legal acts.
And the official reason for this was?
The jurist Gaius, right in the 2nd century AD, tells us the commonly accepted reason was the woman's supposed instability of judgment, levitas enemy. But Gaius himself calls this reason more specious than true.
So even a Roman jurist thought the justification was pretty flimsy. He's basically saying it's a pretext.
Pretty much. Gaius observed that, in reality, adult women managed their own affairs quite capably. The tutor's consent, his auctoritas, was often just a formality for specific major transactions.
What kind of transactions? Why keep the formality if it wasn't really about judgment?
It was mainly about controlling property, especially high-value ancestral property, res mancipi, and preventing women from taking on large debts or legal obligations that might endanger the family estate. The tutor's role was less about protecting the woman from herself and more about protecting the family's assets and inheritance lines from her independent actions.
Ah, so it's an economic control mechanism dressed up as paternalistic concern. What if the tutor refused to give his purely formal consent? Could a woman get stuck?
Here again, the praetor could step in. Gaius notes that the praetor could, and sometimes did, compel a reluctant tutor to grant his auctoritas, even against the tutor's will.
So the legal requirement remains, the formality is observed, but the praetor makes sure it doesn't actually stop the woman conducting her business.
Exactly. It shows the law adapting again, bending the old rules through procedure to match social reality, while still notionally upholding the traditional structure.
Okay, one last area showing status and legal change. Citizenship. Getting Roman citizenship was a huge deal, obviously. But how did it affect families, especially for foreigners, peregrines?
There's an interesting edict from Hadrian about this. It deals with what happens when a peregrine father is granted Roman citizenship. Does his existing family automatically fall under Roman family law structures? Specifically, do his children come under his potestas?
Potestas, that's the unique Roman concept of the father's absolute legal power over his descendants. Right, control over their property, their lives, legally speaking.
Yes, it's a very powerful, very Roman concept. And Hadrian's edict says, no, citizenship for the father does not automatically place his existing children under his potestas.
Why not? If he's a citizen, wouldn't his family become Roman in structure?
It seems the Romans were cautious about imposing such a drastic legal status change automatically. The emperor himself, or his officials, had to review the specific case and make a judgment call. Would it actually be beneficial for the children to be placed under their father's potestas?
So even the granting of citizenship, the ultimate status change, was subject to this careful, centralized control, ensuring that the full weight of Roman family law wasn't just applied wholesale without considering the specifics.
It highlights the state's deep involvement in defining and managing status, right down to the most fundamental family relationships as part of integrating new populations into the empire. #Mark outro.
What a journey. From the chaotic but vibrant democracy of Athens, driven by public debate, rhetoric, huge citizen juries,
Where law felt very immediate, very contested, very much about persuading the crowd.
to Rome, where the genius seems to lie more in the institutions, the procedures, the magistrates like the Praetor, crafting these clever tools, the Edict, the special actions to make rigid laws work in a complex, sprawling empire.
But that Roman procedural genius existed side by side with that incredibly stark, status-based criminal justice system. The flexibility was there, but so is the brutality, legally encoded.
It really underscores that law is never just abstract rules, is it? It's always a tool. A tool shaped by the culture that creates it, by the needs of power, by sheer necessity. Whether it's the Athenians trying to manage direct democracy with lottery wheels, or Roman praetors using legal fictions in their edicts?
Both systems were trying to cope with the sheer complexity that their own political success had created. The Romans perhaps developed more lasting technical solutions through their jurists and magistrates, but at the cost of embedding social hierarchy right into the heart of their justice system.
Which leads us to a final thought for you, the listener, to mull over. Thinking about Rome, with its brilliant procedural flexibility on one hand and its brutal, status-obsessed punishment system on the other, which was the real innovation? Was it the praetor's edict and the law's theoretical ability to adapt? Or was it the system's chillingly pragmatic ability to use law to enforce and maintain a rigid social order, protecting the elite while brutalizing the masses?
What does that incredibly detailed differentiation between honestiers and humiliores tell us about who a sophisticated legal system ultimately is designed to serve?
Something to think about as we navigate our own complex systems today. We hope this deep dive gave you some real food for thought on how law worked and maybe still works in shaping society.